Well, good morning or good afternoon, depending on where you are. My name is Tim Sullivan, and I want to welcome you to Thompson Coburn's Continuing Legal Education Program. The title of today's program is Working with the FAR. Now, we call this program Working with the FAR, and the other name I would use for it is Solving the FAR Puzzle. And this is probably, I guess we'd all have to acknowledge, not one of the world's most exciting topics. And we do appreciate the fact that you're sharing part of your day with us as we try to demystify one of the most intimidating aspects of doing business with Uncle Sam, working with the Federal Acquisition Regulation, the FAR. The real reason that I thought this program was necessary is because of the number of times I've had clients tell me that they were not aware of what they were entitled to get in a debriefing. And as most of you in the listening audience know, debriefings are conducted either in accordance with FAR 15.505 or FAR 15.506. Or clients will call me about a problem that's come up and ask how aggressive they can be in addressing it with the government. And that's when I tell them about the past performance language at FAR 49.1501, and they about faint. I've gotten the same reaction in a number of seminars that I've taught. Now, we're not going to delve into every nook and cranny of the FAR today. If you think that I'm actually going to be telling you about FAR 49.203C-IIAB today, you'd be wrong about that. But I am going to talk about an approach for working with the FAR. And I hope that at the time we're done today, you'll feel more comfortable about your ability to solve the FAR puzzle. Without going any further, I want to read you a quote from a fellow who was a former vice president of tiny Hillsdale College in southwestern Michigan, a very conservative school. And this gentleman, whose name is Ronald Trowbridge, once said, "The FAR reminds me of War and Peace in length and the Inferno in punishment." Well, you know what? If you haven't dealt with this topic and had to work with it every day like most of us have to do, you could absolutely take that view and be correct. On the other hand, once you've worked with it for a while, you realize that the FAR actually has some methods to its madness. So why is this an important topic? Well, first, as we see here, it's because the FAR is the Holy Bible to the federal contracting agencies. And I say most federal agencies there because not all agencies that we do business with are covered by the FAR. We'll talk about that in a little bit. And the more you know about the FAR, the better you'll be able to protect your organization, whether you are with an agency, a prime contractor, or a subcontractor. If you can persuade the contracting officer or the prime contractor that your position is consistent with the FAR, you should be in very good shape. Secondly, in terms of why is this an important topic, primes need to know what they're getting into when they are awarded a contract. There is no more rigorous set of terms and conditions than a U.S. government contract. What's the old saying? The only thing worse than not having a government contract is having one. Well, if you read these clauses sometimes, in the abstract, they could scare the daylights out of you. So you really do need to understand what the deal is that you're getting into. And how about subs? Well, subs certainly need to know the FAR because they have to know what they have to take as flowdowns and what they don't have to take as flowdowns. Now, sometimes that question or the answer to that question is determined by the economic leverage that the prime has, and they have to take it whether they like it or not. On the other hand, if it's a true negotiation and the prime is listening to you, your knowledge of the FAR as a sub is very important. The fact is, in the business as we know it, that quite honestly, primes simply rely too much on, subs rely too much on the primes. They take the word for things. If the prime says it's got to be in there, it's in there, and there's no more discussion. That's incredibly naive, and it's incredibly risky. Secondly, we all grew up with the concept or knowing the old adage, the customer's always right, and the prime is your customer. And if the prime says it's got to be that way, it's going to be that way. Again, in our business, that can lead to trouble. And finally, if you as a subcontractor don't understand exactly what's in your subcontract and how it works, then you have failed to adequately assess the business risk of the deal you're getting into. And the final point on this slide is, why is the FAR an important topic? Because knowledge is power. The FAR is a key tool of our trade, and your ability to become familiar with it is going to enhance your chances for success throughout your career. Now, just a couple of more points before we move on from this slide. First, I'm not a sailor, but my sailing friends tell me that you learn something every time you go out on your boat. And that is actually so true of working with the FAR. I learn something every time I go to it and work with it, especially if it's a new set of facts, because that tends to highlight new things that I didn't see before with an old set of facts, even working with the same regulation. And finally, you don't have to be a lawyer to do this stuff. The fact that it's regulations and statutes obviously gives lawyers a leg up, and it's more in their comfort zone, but it's simply a matter of getting your arms around this stuff, working with it, and understanding how the FAR works. You don't have to go to law school to do that. Now, speaking of law school, what's the relationship between the FAR on the one hand and statutes on the other? Well, let's step back and remind ourselves that there are three sources of federal contract law, and those sources are statutes, and let's just name a few: the Truth in Negotiations Act, the Competition in Contracting Act, the Small Business Act, the statutes that Congress passes and the President signs into law that govern our country and our government and how it works. So the statutes are the starting point. But the fact is that you and I probably on a daily basis don't get to see these statutes face-to-face or close-up. We just don't do that. Instead, we work with the FAR. So the first source of our law and government contracting is the statutes. The second is the regulations. And we start with the FAR, but you work down through the supplemental regulations as well in order to understand how those statutes were implemented. That's what the regulations do. They bring the statutes down to earth, down to the working level, and in the eyes of the courts, they have the force and effect of law. The FAR has been around since 1984, in fact, April Fool's Day, 1984, April 1st, 1984, and it was an effort to combine all the major regulations, really both the major regulations, the Federal Procurement Regulation and the Armed Services Procurement Regulation, or the Defense Acquisition Regulation at the time, under one umbrella, intending really to simplify things, which those of us who were around at the time know it really didn't simplify things. Now, the final point I want to make, 2 more points on this particular slide. We have 3 sources of law. I've talked about 2, the statutes and the regulations. The third source of law is the case law. Those are the decisions out there by the courts and the boards of contract appeals and the GAO that interpret the statutes and the regulations, that apply the statutes and the regulations, that put meat on the bones of the statutes and the regulations. So in order for us to do our job well, we have to have a working familiarity and be comfortable with all 3 aspects of those sources of law. Now again, if you're not a lawyer, that can be a scary thing. Relax, we'll get you there. There are ways to deal with this. On the bottom bullet point on this particular slide, I mentioned something called the Administrative Procedure Act, the APA. That provides the backdrop for everything you do and I do in government contracting. Now, this is a statute that, and for the lawyers in the audience, you probably know it's 5 U.S.C. Section 500 and beyond. This is a statute that does a number of things that affect us every day in government contracting, and we've highlighted just a few of them here. And let's talk about those things. First of all, it requires the agencies, that is DOD or GSA or SBA, it requires those agencies to publish proposed rules for public comment in the Federal Register. Now, I don't know how many people in the audience get a chance to read the Federal Register on a daily basis, but I'm guessing it's very few. But literally, every proposed change to the regulations and every finalized or implemented change to the Federal regulations is published in the Federal Register. It gives the public, under the statute, the APA, the right to comment on these proposed regulations before they're implemented. Many times the agencies will take those comments and weave them into the final regulation. Sometimes they'll ignore them, sometimes it'll actually end up killing the proposed regulation. We've seen that many times over the course of my career. But the fact is that this public comment and public notice aspect of the APA is essential to how our system works, our government system. And for you and me on a daily basis, one of the most important features of the APA is that under the Administrative Procedure Act, agency officials possess what we call discretion. And their decisions cannot be overturned unless a court or a board or the GAO determines them to be arbitrary, capricious, or unreasonable. That is huge. What it really means is that even if a typical case, you'll see it typically at the GAO in a decision where they say, we might not have reached the same decision or conclusion, but we will not substitute our judgment for the contracting officer, and therefore your protest is denied. That is huge in the concept of dealing with federal government agencies. And I always liken the concept of discretion to a huge, thick coat worn by the contracting officer. You might try and poke at it and pierce it, but it's very rare that you can actually pierce it and actually make contact with the body. So this is why, and you'll see a little bit more of this as we go on here, this is why we often counsel our clients, keep your powder dry. You want to choose your battles with the government because some things simply aren't going to be winnable because of the role that discretion plays in the contracting process. I mentioned a couple of statutes already this afternoon, and on any given day, for any particular problem, a particular statute may be the most important of all. But there are two statutes that were passed in the mid-90s that have had such an impact on our business that they deserve mentioning here. And they play right into this APA concept I talked about. The acronyms for these statutes are FASA and FARA. You see them in the first bullet. The Federal Acquisition Streamlining Act of 1994 and the cleanup statute passed in February of '95 called the Federal Acquisition Reform Act. They addressed a number of issues, but one of their primary purposes was to make the world of U.S. government contracts less unattractive to commercial companies. And when I say commercial companies, I'm really talking about computer software and hardware concerns who basically had told the government, you want to do business with us, go to CompUSA because you're a pain to do business with, there's too much red tape, you've criminalized the process, we're not interested. And so the regulations, as a result of this statute, underwent a wholesale rewrite. And the revised FAR, the one we're working with today, you'll see is written in very broad, generic terms that give the contracting officer much more discretion. Now, I hope that all of you understand, all of you got the advice from our firm when you signed on that we hoped you could bring a copy of the FAR with you today. And if you did, that's great. If you didn't, you can take notes here. I'm just going to give you a few examples of how this broad, generic language, this discretion, is embodied in the current FAR. The first example I'm going to give you is at 15.304C. Now, these are the evaluation factors and significant sub-factors that an agency or a contracting officer must use in a negotiated procurement. And you all are very familiar with these. They're in Section M of every RFP you've looked at. And under subparagraph C, it says, the evaluation factors and significant sub-factors that apply to an acquisition and their relative importance are within the broad discretion of agency acquisition officials subject to the following requirements. So basically, the starting point is, this is our call. And your ability to challenge that call or that determination is very limited. I'm not going to tell you it's impossible. It always depends on the facts and the circumstances. But understand that the evaluation factors can be they are subject to the broad discretion of the contracting officer, and the likelihood of a court or the GAO overturning them is therefore slim or slimmer than usual. Now, let's move forward a little bit here. I've been in this business since 1973. First as a contracting officer with the Central Intelligence Agency, and then beginning in 1975 as a lawyer representing contractors out there. And so I've had lots of discussions with lots of people over the years, and I understand the myths that are operating on a daily basis out there in government contract land, and we're just going to talk about a few of them today. The first one is government personnel, particularly contracting officers, know the FAR by heart and certainly better than I do. Well, that is a definite myth. Don't ever assume that the person across the table knows the FAR or more about the FAR than you do. He or she might be brand new to the agency, brand new to the company, brand new to the organization, or they may have never bothered to read this stuff. And it's really not your problem. Your problem is to go into any discussion or negotiation having prepared yourself for it and not worried about how much they know. So that is absolutely a myth. Secondly, second myth, the FAR can only be used as an offensive weapon by the government. Now, I guess this comes from the belief that, and it is true, that the FAR was written to protect the government. It really wasn't written to protect the contractors out there. On the other hand, if you read the FAR carefully enough and you work with it carefully enough, you'll see that there's plenty in there that can be used to protect you. And I'll give you an example. About 5 summers ago now, I was introduced to a company that who had been a commercial contractor and had launched its first government contract effort with one of the civilian agencies and found themselves about $800,000 into the hole after the second, I guess about 8 months into it. And so I got called out to sit down with them, and I met them and we talked it through, and I could see that there was a good claim, and we ended up working on the claim with them and filing the claim, and the agency agreed to give our client another $800,000 because of the changes the agency was responsible for. And they were going to do it the usual way. They were going to issue a modification that would crank the money into the contract, and we'd move on from there. So that was great. I get the modification, and I was not surprised to see at the bottom of the modification that there was release language in there. And they apparently weren't expecting me to read it, because when I did read it, I found out that we would be signing a release that said we not only would release the government from any and all claims prior to the execution of this release, but on anything that might arise throughout the course of the contract, the next 2 years. That's way too broad. And I called the contracting officer and said, look, I'm not going to send this to our client. I've got a problem with this language. And she said, what's your problem? And I explained it to her, and she said, well, I took it right out of the FAR. And I said, well, no, you didn't, actually. If you look at FAR 43.204C and you look at the release language there, and I had it open to it, and I actually sent a copy of it to her, you'll see what the release language is that's recommended by the FAR. And if you're willing to revise the mod to reflect that language right there in the FAR, I'll send it to the client. It got real quiet. She accepted it. We did it, and we got the deal done. But the fact is that in that case, we were able to use the FAR to protect our position and persuade the agency of the correctness of our decision. So once again, you got to know how to work with this stuff. I'm not saying you have to memorize it, but you have to be prepared to work with it. Now, the third myth that we have on this particular slide is I'm a subcontractor, so I have a lot less exposure to the FAR. When I hear that, when I hear companies tell me we only work as a sub because we don't want the exposure that a prime has, my response is always, have you actually read your subcontracts from front to back? Because unless the primes are doing a terrible job, your exposure is right up there with the prime. You're holding hands with them on the front line. And smart primes know that they want to flow down as much from their prime contract to the sub as they possibly can. Now, that doesn't mean the sub has to take everything the prime wants to flow down. And a sub has to know what must be taken, what doesn't have to be taken, what might be helpful to take or just it really doesn't present a risk. But you have to know that you don't have to swallow everything that a prime throws your way. Once again, relying on the prime for the determination of whether you have to take this clause, not a great idea, being done all the time. Now, I don't want to spend a lot of time on this, but let's talk about an overview of the FAR. If you have the FAR with you, I'd like you to go to the very front of the FAR, and I always use a paperback copy so I can mark it up and flag it and things. You'll see there's a table of contents that goes for 2 1/4 pages. And actually, that table of contents is a nice place to start for you as you start to acquaint yourself, familiarize yourself with this intimidating document. And you start with the FAR system, the definitions of words and terms, business practices, then you go to, and that's in the general section, then you go to acquisition planning, and then you go to contracting methods and contract types, where we focus so much of our effort because these are the solicitations that you all compete on and that if you're an agency, you're issuing. Then we go to socioeconomic programs. A reminder that if someone asked you this week, well, is the U.S. government, is the contracting system designed to award the contract to the best company at the best price? And the answer, at the lowest price, the answer is no. No, there are a lot of things that are taken into consideration, including socioeconomic things like your small business subcontracting plan, for example, or small business size status, which means the big companies can't compete. So again, these socioeconomic concerns have been woven into the fabric of government contracting and cannot be taken out. Then there are the general contracting requirements like intellectual property in FAR Part 27. Then you get to special categories of contracting. And then you move into contract management, audits, contract modifications, I just referenced this, subcontracting policies and procedures, government property, and then finally you end up with terminations. So there's logic to the broad layout of the FAR, and here on slide 12 that we have up on the screen, we just talk about an overview. First of all, where is the FAR found in the Code of Federal Regulations, the CFR? It's Title 48. And this slide shows you where the electronic version is, and certainly many people we know work with the electronic FAR only. Once again, I'm a big fan of having a paperback copy that I can mark up and flag and carry with me in my pathetic life. The parts of the FAR are divided into subparts, sections, and subsections. If we flip to the next slide, we take a look at who is actually running the show here. It's issued, that is, the FAR is issued and maintained jointly under statutory authority granted to the Secretary of Defense, the administrator of the GSA, and the NASA administrator. And the statutory authority to revise and issue and revise the FAR has been delegated to the procurement executives in those agencies. And then we have the Office of Federal Procurement Policy, OFPP, which is in the Office of Management and Budget, right in the White House, that provides overall direction for government-wide procurement policies, regulations, and procedures. But don't ever kid yourself about who runs the show here. When it comes to the FAR, the DOD is the elephant in the room. We have the FAR Council, the FAR Acquisition Regulatory Council, that manages, coordinates, controls, and monitors the maintenance and issuance of changes in the FAR. And when there are changes, when there are revisions, they come out in FAR circulars, which also go into the Federal Register. The most recent FAR circular was January 30th. It was FAC, FAR Acquisition Circular 05-72. And again, you don't have to read these acquisition circulars. You don't have to read the Federal Register on a daily basis, but you do need to read a periodical that covers our business and stay on top of that. We have a little slide later on that says it's a two-step process. You subscribe to, and the second step is read one of these periodicals that covers our business, like Federal Contracts Report that's put out by Bloomberg, covers it on a daily basis. It's a great source for all of us, provided you are reading it. The FAR organizational system applies to the FARs and to all agency supplements. The most common one, of course, for most all of us is the DoD FAR supplement. Under the FAR numbering system, the digits to the left of the decimal point, I'm going to slide this to the next slide to show you how it works. So now you've got FAR 15.403-1. So what does that mean? Well, we know it's the FAR, and the digits to the left of the decimal point represent the part number. So it's FAR Part 15. The digits to the right of the decimal point and to the left of the dash represent the subpart and the section. So 15.403. And then the digits to the right of the dash represent the subsection, -1. So you break it down. Now, continuing with that just a little bit, let's take let's break down the overall FAR into two main parts. One part is FAR Part 52. That contains all the standard clauses and provisions that go into your government contract solicitations and contracts. They're all in FAR Part 52. The standard clauses are. And all of them begin with 52.2. The next two digits correspond to the FAR part in which that particular clause or provision is discussed and prescribed. And let's take a look at 52.243-1 on this slide. That's the changes clause for a fixed price contract. Okay, so the next two digits, that is 43, correspond to the FAR part in which that particular clause or provision is discussed and prescribed. And then the number following the hyphen relates to the number of clauses and provisions related to that FAR part. And there are several changes clauses depending on what type of contract you have. So it would be -1 or -2 or -3. So there is a methodology here to the numbering system. Now, we're going to come back to this a little bit later, but if you have a piece of paper in front of you or you have some, it's the 43 that's very important, because that's what tells you where what we call prescription language is that dictates whether and how any clause in FAR Part 52 should be used. We're going to come to that. At the back of the FAR in FAR Part 52.3, there's something called a provision and clause matrix. We call it the matrix, and that is a one-stop shopping summary of all the clauses in FAR Part 52, when they apply, how they ought to be used, and it's a great resource. We're not going to look at it now. But it is something for you to take a look at it if you haven't now. It is a good guide on when clauses are used appropriately. Now, on the top of this slide, you note that I make a point here that each clause or provision listed in the FAR cross-references a FAR section that prescribes when it should or may be included in the contract. That's the prescription that I just mentioned. Now, let me just say here that there is a difference between a clause on the one hand and a provision on the other. Clauses only apply to contracts. Provisions only apply to solicitations. Now, I wish I could sit here and tell you that is adhered to rigorously every day by everyone I know. These things are used interchangeably, but technically that's exactly how they're supposed to be used. Now, if I were going to give you an example of how these prescription clauses work, or the prescription methodology works, I'm going to just thumb through the FAR to 52.216-7. So if you've got your FAR with you, if you go to 52.216-7, you'll see that that clause, I'm just about to get there, is allowable cost and payment. And it starts, as all these clauses do, with the following language. As prescribed in, it means FAR Part 16.307A, insert the following clause, which means I have to go back to the prescription language, 16.307A. And if I go back there, I see that it says, the contracting officer shall insert the clause at 52.216-7, allowable cost and payment, in solicitations and contracts when a cost reimbursement contract or a time and materials contract other than a contract for a commercial item is contemplated. So that's the prescription. If it's a firm fixed price contract, you shouldn't be using this clause. No matter what the type of contract is, if it's a commercial item, you shouldn't be using this clause. So always, before you delve into the clause in the language in FAR Part 52, check the prescription, match them up together so you understand the context within which you are working in each case. We've talked about the supplements. When FAR was passed in April of '84, became effective in April of '84. The supplements came out right away. DOD in particular was concerned that the generic nature of the FAR wouldn't be specific enough or meaningful enough to cover all of DOD's many programs and concerns. And so they convinced the Senate that they had to have the right to issue a supplement that in theory didn't contradict the FAR, usually supplemented it If it was going to contradict it, that would require a waiver process, which exists. But basically, if you've got the paperback versions like I do, my copy of the FAR is almost the same size as my copy of the DoD FAR supplement. So the supplement's an important thing to be looking at. And they number chronologically, they're consistent. So, for example, FAR Part 27, which covers patents, data, and copyrights, is supplemented by DoD FAR Supplement 227, patents, data, and copyrights. Now, just stop there for a second. That is a great example of a situation where the really important provisions, the really important clauses and provisions relating to data rights, if you're a defense contractor, are contained in the DoD FAR Supplement 227. FAR is very generic on data rights issues. And the real issues, the real meat for a DoD contractor is in the supplement. So you can't avoid the supplement. Now let's take this a little bit further. Let's say my contract is an Air Force contract. So it's covered by the FAR, it's covered by the DoD FAR supplement, and it's probably going to have Air Force supplement clauses in there to check as well, as you see at the bottom of the slide. Again, the numbering is consistent. Now, I think I flipped one slide too many. Okay. Now, agency supplements that supplement the FAR, that is, discuss something not addressed in the FAR, must utilize the number 70 and up. So, for example, with the Department of Interior, whose assigned chapter number in Title 48 is 14, they'd use 1470, 1470, or subpart 1401.70. The 70 or higher signals this is different, this is more. Another example in DoD, the weighted guidelines, 215.404-71. It's a signal that this is different, it's more than is in the FAR. So let's take a look at some basic principles of working with the FAR. First of all, and I know in an academic setting, such as the one we're in right now, this is going to sound a little bit silly, make sure you're working with the right regulation. Well, what do I mean by that? Well, I can tell you about a case I had in the mid-'80s, yes, I'm that old, where the Navy came to one of our clients and said, you know what, we think the data rights markings that you put on your drawings in our contract that you finished performing in the late 70s, we think you overmarked that data. We think that we're going to remove your data, your proprietary data rights, restricted rights legends from those things and issue them to the public, and you've got 60 days to tell us why we're wrong. Well, the client tried to battle the Navy on its own and fight them, and the Navy just kept pressing, and then they called us, and we took a look at it. And what was fascinating to us out of the get-go, or from the get-go, was that the Navy was applying the FAR as it was written in 1984 to the problem, whereas the regulation that was in effect when the contract was awarded in 1968 is the regulation that was supposed to govern that contract throughout its life. And so the first thing we said to the Navy was, you're using the wrong regulation. It's not the current version of the FAR, it's the old Defense Acquisition Regulation, actually it was the old Armed Services Procurement Regulation that was in effect in 1968. Here's how it read then, and these are the procedures that you have to follow in resolving this matter. So, it's always make sure you're working with the right regulation. And as a basic rule, the regulation in effect on the date your contract was awarded will always govern that contract unless the parties agree otherwise. And they can. There have been situations, we've seen them, where regulations have changed and the government agencies have come to a company and said, we want to modify this contract to bring this new regulation in. Now, let's not even get into how you respond to something like that now, but certainly since it wasn't part of the original deal, it might present risk for a contractor and has to be looked at very carefully. Okay, so always make sure you're working with the right regulation. Secondly, the FAR does not cover all federal agencies. I mentioned this at the very beginning of our program. For example, many of you might do business with the FAA or the Postal Service. Now let's go to the FAA. We all know that's part of the Department of Transportation, and the Department of Transportation is a federal executive agency, and DOT's contracts are covered by the FAR, but not the FAA. They've got a carve-out. They have their own set of procurement regulations, and if you're going to be doing business with them, you have to become familiar with those regulations. And by the way, when you compare it to the FAR, it's laughable. It's about 1/4 of an inch thick, and the basic message in the FAA regulations is, if we want to do something, we can. So it's a lot different than the FAR. The Postal Service, again, it's not a federal executive agency in the common sense of the word. It doesn't operate on appropriated funds, because it operates on funds it gets from the postage stamps you're now buying at, what, 50 cents a copy now, or whatever they are. Postal has its own set of regulations. If you're going to do business with these people, it doesn't mean it's a bad situation, but it means you have to be aware of the fact that they have their own regulations. Finally, always check to make sure that your copy of the regulations is current. And that is why the electronic versions of the FARs are great, because before you reach a final decision on something and you've been using with your paper, I get a new copy of the FAR every January. You always double check to make sure it hasn't been changed over the course of the year. And because this is an evolving document. And while the changes clause and certain other very fundamental clauses are going to be the same, things do change, and it's worth double checking. Next, as we've hinted a couple of times, always try to ascertain the relationship between the FAR's prescriptions and the standard clauses. We've talked about that. I'm not going to beat that to death here, but understand there's a relationship between every clause in FAR Part 52 and a prior section or part of the FAR. Second, if the FAR language is not clear on its face, check to see if there's any case law out there that explains or applies the language. Now, we've talked about what case law is, and I'll just give you a very simple example. If you look at FAR Part 15 and you look at the section in FAR Part 15 that talks about the contracting officer's requirement to conduct discussions in a negotiated procurement once they've established a competitive range and they've got different competitors in there, and this is all in FAR 15.306. Once a contracting officer begins to engage in discussions, he or she's got to follow the broad outline of the rules in there. But you could read that regulation from now until the cows come home, and you'll never see any language that says these discussions must be meaningful. And yet there are hundreds of GAO decisions which say when an agency engages in discussions, they must be meaningful. So the case law, that's a great example of the case law putting a gloss on the language, adding a little meat to the bone of the regulatory language we've got. And it's very helpful when you're scratching your head on a particular concept to take a look at a couple decisions that apply it or interpret it. I had this happen to me last week in dealing with a statute called the Cargo Preference Act. And it's not a model of clarity, and the regulations aren't a model of clarity. So when that happens, we go to the case law, see what it tells us, see if it helps us make sense. Now, if you've done those things, you've read it, you've checked the prescription, you've looked at the case law, and you're still fuzzy, you're still puzzled about this, go for help. Check with your boss, talk to your lawyers, call a friendly contracting officer, call a contracting officer in another agency and ask her, who's friendly with you, ask her how she thinks it works, but don't plunge ahead without getting resolution on this if you still don't understand the language, because that's a perilous path. Always check the table of contents and the topical index before you delve into a problem. The FAR isn't written in a perfect way, and certain topics might actually pop up in different parts of the FAR. And so the concept of past performance, for example, it's in FAR Part 49, it's also in FAR Part 15. You need to read them together to kind of understand how they work. So always use the topical index if you're a stranger to this stuff, and exhaust the regulation tree. As I said, if you're working on an Air Force contract and you're concerned about data issues and you've got a data rights issue, you start with the FAR, but the real meat's going to be at the DoD FAR supplement and possibly in the Air Force FAR supplement, and move down that tree until you've exhausted that regulation tree, so you've looked at everything that covers the particular problem before you make your decision. don't ever assume you know the FAR by heart. I've been doing this since 1973, as I said. And I'm pretty familiar with many sections of the FAR, but thank God I haven't memorized it all. And I haven't memorized any of it because it changes. Why would you bother memorizing it? And here's the trick about the FAR, and that's really in the last bullet on this page. It's written in very broad and abstract terms. Terms that can cover a lot of different situations. And so what I have found over the years, if I go to a particular provision or some language in the FAR, and I've got a set of facts today, and I resolve my problem by working through the FAR language as I place it alongside these facts. 3 weeks later, if I go back to the same language in the FAR but a different set of facts, now I notice that there are other words in there that kick in and become effective. So the FAR is a bit like a chameleon. It changes colors depending on the facts you put up against it. And you've got to go back and take a look at it, even if you have worked with it before. Now, let me just give you a working example here just to show you how it works. Let's say that you've got a proposal due today in Baghdad at 3 o'clock local time. And you can send your proposals in electronically. And like so many of us do, we wait till the very last minute to do it, right? So you wait until 2:45 Baghdad time, you're here in the States, and you push the send button. Now, what happens? Well, it hits the Army's servers all right over there in Baghdad, but because of all the security protocols, it bounces around, and around 4:15 that afternoon Baghdad time, it finally appears on the contracting officer's screen, and she sends you a message saying your proposal was late. Okay. Now, how do you deal with that? Well, you take a look at the solicitation and you try and figure out what provisions apply. And the likelihood is you're going to find that the provisions that FAR 52.215-1, the instructions to offerors for a competitive acquisition, are going to be the rules of the road. And if you take a look at that, now, if those of you who have the FAR, turn to 52.215-1 and take it down to subparagraph 3. And that's where we talk about late proposals, and they deal with all the different ways this can happen with courier services and personal delivery and the whole 9 yards. And believe me, there are horror stories here. And let's focus on the language that says what happens with electronically transmitted proposals. And I'll read it to you. It's subparagraph 1. If it was transmitted through an electronic commerce method authorized by the solicitation, it'll be okay to accept it, even if it was late, and then it has this exception. If it was transmitted through an electronic commerce method authorized by the solicitation, it was received at the initial point of entry to the government infrastructure not later than 5 p.m. one working day prior to the date specified for receipt of proposals. Well, you didn't send it before 5 o'clock the day before. You waited until 2:45 of the day of to do it, so you're in trouble with this. Now, you might conclude that you're dead here, and there are plenty of people who would be dead here, and if you protested to the GAO, you would be dead here. On the other hand, if you protested to the United States Court of Federal Claims, you would find out that Judge Braden and another judge or two there have issued decisions saying in those very circumstances that I just outlined, the government should accept the proposal. So, the regulations are a starting point, but not the ending point. And again, you have to have an understanding of all three things, the statutes, the regulations, and the case law to really protect your organization. Okay. Let's talk about the concept of terms of art. In every business, in every industry, there are terms of art. Words that are peculiar to that business. In our government contracting business, for example, if you went to a cocktail party this Friday night and you told someone the punishment you've been subjected to today in this 1-hour seminar, they'd say, oh, it's so great that we're talking. Our contract was just terminated by the Navy. Is that a good thing or a bad thing? Could you answer that question without delving in a little further? Of course not. You'd have to say, well, let me ask you, was it a termination for convenience or was it a termination for default? Because there are two very different things, aren't they? Those are both terms of art in government contracting. We have plenty of them in our business, and you have to be familiar with them. Now, on this slide, we talk about other terms. For example, the term discussions. When you and I are talking with each other on a daily basis, that's a discussion, but it's not discussions under FAR Part 15 as it's defined in FAR Part 15. So to understand the full meaning of these words in our business, you should start by checking to see if they're defined in the FAR. Most terms are defined in FAR Part 2. For example, the concept of commercial item, which is huge in our business today, that is in FAR Part 2. If a word or a phrase is in FAR Part 2, the definition applies throughout the FAR, unless the context in which the word or the term is used clearly requires a different meaning. Otherwise, that is used throughout the FAR. But if a word or a phrase is defined in another FAR part, then that particular definition only applies to that part. And discussions is a great example of that. It's only defined in FAR Part 15 and only applies to FAR Part 15. Now, the final bullet on this page is going to make a lot of you very unhappy because I'm very familiar with the fact that many of you, upon leaving college, took your dictionaries and tossed them. Well, let me tell you, we use dictionaries every day in our practice of law. And we use them in the briefs we write and the arguments we make because words mean something, words matter. And in the FAR itself, undefined words retain their common dictionary meaning. So maybe you need to go out and buy another one or steal it from your kid, but that dictionary is something that can be very valuable to you. Now, some terms of art are derived from the case law. Again, the lawyers are the ones who, in theory, would know this, but it isn't something for you to be scared off. Don't be scared off by this if you're not a lawyer. If you subscribe to and read periodicals that cover our business, you're going to become familiar with these things. And the example I've got, two examples here. The first is the course of conduct doctrine. That is a doctrine of case law. You can go through all the statutes that cover our business. You can go through all the regulations that cover our business, and you will not see the phrase course of conduct. On the other hand, when an agency and a supplier have engaged in a course of conduct over a series of several contracts, and they have ignored the clear meaning of language in those contracts, then it might be perfectly appropriate for a contractor to rely on that course of conduct as it bids on the next job. This is how this kind of thing comes up. So again, we have terms of art in our business, and course of conduct is one of them. Meaningful discussions would be another term of art, again, in our business that I just talked about. So, in other words, there are things outside the FAR that can affect the meaning and the effect of the FAR, and that's why you and I, whether we're lawyers, keep up with the case law. We read a periodical or two that covers our business. It's not the Washington Post, it's not the Wall Street Journal, but it is very important that we are on top of these case law concepts. One of the most important words in the FAR, and it's in there many, many times, is the word shall. That means has to, it's the imperative. They've got to do it. Webster's dictionary says that imperative means absolutely necessary or required, and FAR Part 2 makes that very clear. Shall and must mean the imperative. On the other hand, if the language simply says may, that indicates the permissive. It means the contracting officer doesn't necessarily have to do something. And you see examples of this throughout the FAR. I'm going to take you to FAR 15306C right now, where we're talking about the competitive range situation. And it talks about how agencies shall evaluate all proposals in accordance, and if discussions are to be conducted, establish the competitive range. And the word shall is all throughout that particular paragraph. Again, it's the imperative, and they've got to do that. Let me see if I can start wrapping up here and finish with some tips for both the primes and the subs out there. Okay. First of all, stay on top of changes to the FAR. Subscribe to a periodical that covers our business, like Federal Contracts Report, for example, or have someone monitoring the Federal Register on a daily basis. But the fact is, you've got to stay on top of our business. Second, always review the RFP to make sure it has the right clauses in it. You want to make sure that you're protected, that you're not overexposed in these situations. You want to point out to a contracting officer if he or she has put improper clauses in there and resolve that before offers are due. And that's what that next bullet is about. Always resolve concerns or questions about an RFP or an IFP before offers or bids are due. And be prepared to tie your position to the FAR. Do not make the mistake of saying, well, look, let's just put this in our back pocket. We won't say anything, and if we win, it's not a problem, but if we lose, now we have a protest basis, because that's not going to work, because anything that was apparent from the face of the solicitation it cannot be used after offers have been submitted. That it would be an untimely protest. Every government lawyer knows the argument. So always raise these concerns before offers are due. And if I am a prime contractor, I'm going to use my prime contract as a guide to preparing my subcontracts. Don't flow down more than necessary. I know the tendency to flow down everything. Don't flow down more than necessary. Next, primes, watch out for local clauses in a solicitation. You shouldn't get in trouble when it's the FAR or the DoD FAR supplement, but you look at these solicitations and you'll see, let's say that you're doing something with the Naval Supply Center Norfolk. You'll see a clause that literally is a Naval Supply Center Norfolk clause. Hasn't been to the Federal Register, hasn't been out there for public comment. It's written at the Officers Club over a couple of martinis in an effort to make sure that the way one contractor just took advantage of the Navy won't happen again. These are troublemaker clauses, these local clauses. Always make sure you check them out if they're referenced in a solicitation. Usually they just incorporate them by reference. Read them. Second, beware of this notion of boilerplate. We all think that all these RFPs, these solicitations are filled with boilerplate, and in many cases they are, but take a look at them to make sure you understand what's in there. And if I am a prime contractor, don't use a one-size-fits-all approach to drafting your subcontracts. You don't want to do that. It's lazy, that's sloppy, and it leads to big problems with your subs in terms of contract administration. For subs, always review a proposed subcontract carefully to ensure you can live with its terms, of course. And we could do hours on this, and we do, but I mean, the payment clause, for example. Is the prime setting it up so they're only going to pay you 30 days after they've been paid by the feds? That could put you 6 months out from a paycheck. Read those things. When it comes to flow-down clauses, determine whether they are appropriate. Check for altered or camouflage clauses. We've seen primes say, well, this is FAR 52-249, and it's not. They've altered it. You've got to look at the language that's in there. If you are aware that a clause is not a mandatory flow-down, you need to make a decision as to whether and how to challenge it with your potential customer here. No one likes to get in a fight with a customer beforehand. Once again, your knowledge of the FAR is vital in making these decisions. And again, beware of boilerplate. Beware of a prime contractor saying, look, that's the self-deleting clause. You hear that, say, well, if that's the case, let's delete it ourselves and initial it and throw it out. Or that's our standard agreement. Those are our standard clauses. That's not an argument that's valid. That is not a valid argument. If it's not supposed to be there, a particular clause, challenge it. And this is great. This is under a tip for subcontractors clause, but since so many of us double as subs and primes, here are two great sources for us in trying to decide what goes into a subcontract. Two wonderful sources that we use all the time. Always remember, these guides are tools. They're not the original source, but they make it easier to confirm things if you have any doubts. I'll wrap up with solving a problem. First, no matter what problem is brought to your desk, before you move down the path of trying to resolve it, make sure you've got all the facts. Until those are nailed down, the next step is a waste of time. Then ask two questions. What does the contract say? Now, I can tell you from experience that they either know, but they don't want to tell you, or they don't know and they don't want to admit it. But most of your problems are going to be resolved by the answers to that question. What does the contract say? And what do the regulations say? And again, make sure you have the entire contract, all the amendments, and the correct regulations. Those two questions will resolve more than 80% of the problems that come to you, even if you don't like the answer. For the remaining 20%, you'll need to review the case law and make it a business decision on how to proceed. So, the FARA is here to stay, and you and your team need to become familiar with it. The knowledge of the FARA is a key to success, regardless of who you are. Be proactive. Keep up on our industry through regular reading of periodicals that cover our business. And finally, develop a lessons learned program for your organization where, at least quarterly, you're getting together with your team and talking about what one person learned on a particular problem with a particular agency or a particular prime or a particular sub, so that you can take this knowledge that one person gained and make it institutional knowledge. We have a program for licensing for the government contractor on March 20th, and on April 8th we have a program on contractor interpretation. These are very useful nuts and bolts programs that we hope you'll join us for. Our team loves to put these things on, and we hope you'll join us for, and you certainly know how to sign up. I'm going to wrap up now, and thank you all for joining me today. I'll answer one question before I wrap up, and that is case law uniform across federal circuits, or does location matter? It's a great question. The answer is it's not uniform. Circuits can have different positions on things. But in our world of government contracting, usually we're talking about the United States Court of Appeals for the Federal Circuit being the preeminent court in terms of any case law, and if they've addressed something, that's usually what the rule of the land is. Second to that would be the United States Court of Federal Claims. That's very important. And then beyond that, boards of contract appeals and the GAO. And if we're at the GAO, for example, we only cite the GAO opinions. If we're at the claims court, we try to cite to claims court opinions, and we bring in helpful GAO precedent when we can, because the claims court respects the GAO, but they don't feel bound by the GAO. And so it really depends on where you are. But you don't really worry about the 10th Circuit and the 11th Circuit, because they don't with in on most government contract cases anymore with the system that we've got. Okay, I'm going to wrap up there. Thank you for spending the last hour with us with Thompson Coburn. Hope you have a great afternoon, and we hope you'll join us for our programs in the future. Thank you very much.